We'll hear argument next in Case 13-534, North Carolina State Board of Dental Examiners versus the Federal Trade Commission. Mr. Mupan.
Mr. Chief Justice, and may it please the Court. A state regulatory agency does not lose its state action antitrust immunity simply because the agency is run by part-time public officials who are also market participants in their personal capacities. The FTC's contrary position that the agency's officials must be disinterested cannot be reconciled with this Court's jurisprudence for three reasons. First, respect for federalism requires deference to a state's sovereign choices concerning how to structure and manage its own regulatory agencies. Second, the regulatory conduct of public officials who are also market participants cannot properly be equated with the conduct of private business people. And third, the FTC's position would be massively and needlessly disruptive. States obtain valuable benefits from using market participants as part-time public officials. They gain the benefits of their expertise, and they gain the benefits of not having to have a full-time bureaucracy with a full salary.
Is it a question of federal law or a question of state law, whether the members of whether this board is a state instrumentality?
Ultimately, whether this board should be entitled to state action immunity is a question of federal law. But in whether characterizing the board as public or private, we submit that, absent extraordinary circumstances, the federal court should treat a state's designation of a state entity as public, and that when that entity is charged with public duties as a state entity.
Well, if you agree that a state can't simply deem something that, for all other purposes, is private to be a state entity or instrumentality, there has to be some test. So what would the test be?
So we think the fundamental key is that it's not just that they're designated as state officials, but they are charged with a state law duty to enforce state law. They are not acting pursuant to their unfettered private discretion to choose whatever choices maximize their personal profit. They are obligated.
In this case, they didn't enforce state law. One puzzle in this case, why should there be an antitrust exemption for conduct that is not authorized by state law? The objection here was that this board was issuing a whole bunch of cease and desist orders. They had no authority to do that, no authority at all.
Well, 2 points about that, Your Honor. First, it's not quite right to say that this board didn't have authority to issue these letters. It is true that the board doesn't have authority to issue self-executing orders akin to an injunction. But it is also true that the board has authority to send letters to prospective non-dentists saying that if you don't cease and desist your conduct, we will sue you. The only question in this case, in terms of state law authority, is whether the wording of these letters was somehow problematic. No state court has ever determined that that is a problem, and more fundamentally, all of that is a question about whether there's a clear articulation here. And the FTC has assumed that there is a clear articulation.
Mr. Mupan, can I take you back to Justice Alito's question? Because I think you said in response that the question, that the answer was, has the state asked the organization to enforce state law and entrusted them with that responsibility. So suppose a state just looked around and found a trade association and said, we think that trade association is going to be a very good enforcer of state law, and made the trade association a state entity. That's the board that's going to regulate this industry. Would that be sufficient?
If they had if they took an oath to the state to enforce state law, if they were subject to the traditional duties that a public entity has, if they had to comply with the Administrative Procedures Act and the Open Records Rules and the ethics laws, if they were subject to judicial review, absolutely.
Well, which of those are the important ones? Do all of them have to be there?
We think the absolute key is that they're subject to a state law duty, that they've sworn an oath to the state to enforce state law and not to maximize their own private.
I think in the trade association case, I get off your train. It seems to me it's quite different to appoint what should I say, an entity that is already a conglomerate, which is already a contract or combination of individuals, and to authorize that separately created combination of individuals to enforce state law. I think that's quite different from saying we're going to have a board composed of dentists and we're going to pick the dentists.
Well, it is different, Your
And
Honor.
they're serving only in their individual capacity on this board, whereas the people in the trade association you're talking about are, I guess, the governors of the trade association are elected by the members, right?
Well, but that's the key, Your Honor. I agree it is a more difficult case, but if the state law had basically drafted a private trade association and said you will serve two hats, sometimes you will act as a private trade association, but sometimes you will be the entity of the state that is responsible for enforcing state law. You have a state law oath to enforce state law. You cannot take your actions to maximize your private gain. What you're doing here is enforcing state law.
My goodness, there's a lot of cases. I would have thought it was well established that if, in fact, the state says to a group of wine merchants, you go fix your own wine prices, be sure they're reasonable. Or to a group of truckers, you go set your own trucking prices, but be sure they're reasonable, et cetera, that they can do that if and only if there is supervision. And because, they might get out of hand, the wine merchants or the truckers or anybody else. Now, I started from that proposition. You seem to be questioning that proposition.
Not at all, Your Honor.
Right, if we accept that proposition, then how is your case any different? Because what we have here is we have a group of dentists, like the group of wine merchants, like the group of truckers, and of course they're not fixing prices. What they're doing is deciding who will be in the business, and there we are. End of case. Is there supervision, yes or no? The FTC says no, there isn't, and I don't want to know what you say.
The fundamental difference between the hypothetical you posed in this case is that when you have private people who are authorized to set their own prices, even if the state statute says they must be reasonable, they are exercising their discretion about what is reasonable in terms of maximizing their personal profit. They are not acting as fiduciaries of the state. They have no obligation to the state. They have not sworn an oath to the state. They're not subject to the state's administrative procedure.
No. We put all that in.
Any of that.
We put all that in. We say our truckers and our wine merchants swear an oath. I swear that I am a member now of the State Commission setting prices, and I swear that I will be reasonable. Okay? You think that would have changed the Mid-Cal result?
Well, since those are essentially the facts of Parker, I do think it would actually change the result. The commission in Parker.
All that happened is they take an oath. For all I know, maybe the Mid-Cal wine people did take an oath.
They didn't. And
okay, suppose I say I don't.
It is no small thing.
Is there anything else? Is there anything else besides the oath? Is this case identical to Mid-Cal, except they took an oath?
No. So compared to Mid-Cal, there was literally no substantive standard whatsoever in the California statute. They were free to set whatever price they want, not even a reasonableness constraint. In addition, not only is there the oath, there's the fact that they're subject to all the traditional duties that public entities have. They have to comply with the APA, the state ethics rules, open meetings rules, public records laws.
But
none of that was.
Why isn't it entirely reasonable to say, yes, this can be a state actor, but because they're made at the same time, the state says they must be in private practice. So they're both a state actor and they're a private actor. So, yes, you can have such a board, but there needs to be a check of supervision. That is, they can't just go make their regulations without approval from some state entity, and they can't go around issuing cease and desist orders. They have to come to a court if they wanted, and the court would act as the check. Why shouldn't, because of the risk that these people have a self-interest, why shouldn't there be a check of the kind that Mid-Cal?
Because fundamentally it is a question for the state to determine whether it wants to bear that risk. These are the state's officials, and the state has made a different choice. The state has decided that the benefits of having market participants make decisions and not having each and every decision actively second-guessed by a higher level of bureaucracy is worth it.
That it really begs the question. If we give immunity because only when we have a clearly defined state intent, a policy accepted and created by the state, how is the state doing that when all it's doing is letting dentists elect the representatives of their board? This is not an appointed position. This is an elected position by dentists of each other. How is the state going to be any different in giving that group of private actors a pass on antitrust litigation that when they have a self-interest that's inherent in their occupation?
Well, The state gets involved at the front end in two ways. First, there has to be a clearly articulated anti-competitive policy. And
what is that clearly articulated policy?
In this case, it's been assumed by the FTC that is satisfied here. What I would submit is the reason it exists is because the Dental Practice Act says that only licensed dentists can practice dentistry. That is on its face inherently anti-competitive.
Yes, but is there any clear policy that teeth whitening is the practice of dentistry? I thought that was determined before the standard about removing stains on teeth, that was before anybody ever knew about whitening.
That's an interpretive question under the statute, and what this Court has held in cases like Omni is application of a clearly articulated state policy is a question for state administration.
But how can it be clearly articulated when the problem being addressed didn't even exist when the policy was
for the same reason that in Omni, for example, the state had authorized zoning, but they hadn't